Welcome to the Neufeld Legal Business Law video series. My name is Christopher Neufeld and I am a corporate commercial lawyer with nearly 20 years of legal experience with a strong emphasis upon business development. In this particular video, we will be looking at the incorporation process, in particular 6 common mistakes when incorporating. Mistake number 1, misunderstanding provincial versus federal incorporation. In Canada, you have the choice to incorporate provincially or federally. Although you might be looking at running a nationwide business and believe it is more cost efficient to incorporate federally, you will still need to extra provincially register in each province that you conduct business. Understanding the implications of one or the other can be quite significant. Mistake number 2, not naming your corporation. A named corporation provides added legitimacy to your business operations, given that many view numbered companies as either holding companies or some shady business operation that is lacking in legitimacy. Also, should you choose to subsequently get a trade name, reference will constantly be required to the numbered company in all legal documents and financial contracts, which can be a problem that might otherwise have been avoided. Also, you will receive legal protections in relation to the use of that name for a company in Canada. Mistake number 3, incorrectly or inadequately structuring your corporation. From a legal and long-term business perspective, corporate structure can be immensely important. The Articles of Incorporation specify, among other things, what kinds of shares the corporation will offer, how shareholders will be paid, and what voting rights the shareholders will hold. Unless you properly describe the share capital and other aspects of the corporation from the start, you will have to perform various modifications, which takes time and often brings additional fees. Instead, you should be creating sufficient flexibility so as to meet changes and developments in your business. With an adequate array of share classes, the company will have the capacity to offer more options for potential shareholders, while also providing more options during tax or financial planning. Similarly, in anticipation of future growth, you'll want to provide for unlimited authorized share capital and allow for a range of directors. Mistake number 4, not having a shareholders agreement. When launching a business with another person or when bringing on a new business partner, entrepreneurs can set their sights on growth, leaving formalities like a shareholders agreement on the back burner. Unless you take the time to get it done at the beginning, it might simply be forgotten, and that could be a costly mistake. No one knows what the future holds, but there are plenty of unplanned events that can occur and negatively impact your corporation. What happens in a corporation if a shareholder wants to exit the company, goes bankrupt, commits fraud, passes away? The law is silent on these matters and many more. Given the expectation that you are sophisticated business people, and if such cataclysmic events do happen, you'll be left in a legal gray zone, and getting such matters resolved often requires lengthy and expensive legal proceedings. A well-drafted shareholders agreement tends to be the best way to avoid future headaches. It helps safeguard you against the consequences of unplanned events and their impact on partners and shareholders by setting down in writing what actions will be taken in varying circumstances. When unexpected events occur, many entrepreneurs have been saved by the terms of the shareholders agreement they made sure to sign at the outset. Mistake number 5, not getting legal assistance from the beginning. A recent study estimated that 60% of small businesses experienced a significant legal event in the last 2 years, and only half of them sought the help of a lawyer to deal with their significant legal event. And whereas some of these business owners may have escaped without a scratch, in most other instances, the situation tends to be far worse without the experience of a knowledgeable lawyer, especially where clever preventative legal measures could have been undertaken that either prevented or limited the legal problems that might otherwise have arisen without experienced legal counsel. And this includes correctly incorporating and putting together the appropriate supporting legal documents, which is best undertaken under the guidance of an experienced lawyer. Mistake number 6: not disclosing important information to your lawyer or your business partners. Whatever is going on, tell your lawyer and your business partners about it. All of it. If you don't, really bad things tend to happen. So don't sugarcoat your situation or what is happening, given that most things can be rectified if tackled immediately. Yet if they are not promptly addressed, they have a tendency to get progressively worse and have a far more substantive impact on the business and create even more serious problems, which can be exceedingly destructive for the business and the relationship amongst the business partners. For legal representation and effective legal counsel in the realm of business incorporation, from incorporating a new company to drafting a unanimous shareholders agreement and more, feel free to contact myself by telephone or email as set forth in this video or through our website www.lawyerincorporation.com. Thank you.